Good morning and welcome to the CABE webinar for the 11th of March. This morning we are with Ruth Wilkinson on the art of getting paid. So my name is Jordan and I am the Regional Services Administrator here at CABE, and I will be acting as moderator for this morning's session. We like to make our webinars interactive, so please feel free to send through any questions that you may have. You can do this either by the control panel that will appear on your screen, or you can send them to us via YouTube. Or if you're watching this on YouTube this morning, then please send any questions through to info@cbuilde.com. If you're on Twitter, you can chat to us by using the hashtag CABECPD. This morning's presenter is Ruth Wilkinson. She is a construction partner at Clark's Legal. She has over 12 years experience advising on both construction disputes and front-end contract drafting and advisory work. She has acted on behalf of employers, developers, contractors, specialist subcontractors and professional consultants. Her work is very diverse and involves a wide range of different projects throughout construction and engineering. So if you give me a couple of minutes, I'm just going to hand over to Ruth now, and then she will take control and go through this morning's presentation with you. Any questions that come through, we'll go through at the end, but I hope you enjoy this morning's webinar.
Good morning, everybody. I'm assuming that my computer says you can see what I'm doing, so hopefully you can. Thank you for joining us this morning. And as Jordan said, the subject of this morning's webinar is getting paid. And what I'm going to hopefully do today over the next 45 minutes or so is set out 5 tips for getting paid. There should be some time at the end for questions and answers. Now, as we all know, recovering overdue money carries a huge administrative burden and cost, and it also has a huge negative impact on commercial relationships, acting as a barrier to strategic and collaborative relationships and inhibiting investment in productivity. There are a number of measures which have been taken by government, measures you can take and preventative actions you can implement to reduce the risk of payment problems and potential disputes on your projects. So this is the agenda slide. It's just a bit of an overview of the topics we're going to be covering today. We're going to be looking at a number of issues, from the measures the government has put in place to deal with late payment, the issues around insolvency and retentions, through to interim valuations, notices, conditions precedent, and the avoidance and resolution of disputes. Most of the talk will be framed in the context of the JCT 2016 Design and Build subcontract, but the principles will be applicable to other forms of contract. By the end of the talk, we'll have covered off 5 key takeaways to apply to your projects and contracts. So tip 1, so agree fair payment terms. The first tip, and probably the most important tip, is to try and agree fair payment terms at the outset, if you can. Ideally, you're looking to work on a contract where there is a fair payment scheme. You're looking at 14 to 28 day payment terms, ideally, no retention, and no pay when paid provisions. When you're reviewing contracts before you enter into these, look out for any amendments in the terms of any contracts relating to payment, particularly any onerous terms. You don't have to accept amendments if they're unfair, and as a last resort, you should be able to walk away from a bad bargain. There should always be an opportunity to negotiate, and the old adage, don't ask, don't get, is a wise one to remember here. I'd also recommend that you seek legal advice in relation to contracts, particularly ones where there's difficult and onerous terms. I would say that, but so often clients arrive with a problem that they either didn't spot or didn't think they should worry about until it was too late, and getting help early can avoid problems later on. So on this particular slide, there's a whole list of different government measures that have been introduced. I'm not proposing to go through all of these, but only the ones that are highlighted in red. These are the so-called highlights. So the first one that's highlighted is the Construction Act, which of course is the Housing Grants, Construction and Regeneration Act of 1996, which was amended by the Local Democracy Economic Development Act in 2009 and came into force in 2011. This requires construction contracts, as defined, to include specific provisions relating to payment and the right to adjudicate. This is a statutory scheme for a 28-day payment dispute resolution mechanism at any time. It also includes the right to suspend or part suspend for non-payment, subject to the giving notice, and there's also a prohibition on pay when paid and pay when certified provisions. If the contract is a construction contract and does not comply with the terms of the Construction Act, then the terms of the Scheme for Construction Act will apply to fill that gap. This is probably the single most important piece of legislation for construction projects and introduced payment requirement in the most recent amendments for payment and pay less notices, which we'll come to talk on later in the context of the JCT subcontract. The next item I wanted to draw to your attention was the Public Contract Regulations of 2015. These require that 30-day payment terms are included in all public sector supply chain contracts, regardless of value. In addition, from September 2019, any supplier who bids for a government contract in excess of £5 million per year will be expected to meet a standard of paying 95% of invoices in 60 days across all of their businesses. If they fail to comply, they could be prevented from winning government contracts. The guidance also recommends using project bank accounts. Businesses can report late or unfair payment in public sector contracts to the Public Procurement Review Service, and according to gov.uk, this service has unlocked £7.5 million in late payments since 2015. The final topic I just wanted to touch on was project bank accounts. Now, project bank accounts can help ensure secure and regular payment and protect against the risk of upstream insolvency. Monies in a project bank account are held in trust by the overall client and the main contractor, and the project participants are paid out of the same account. The government has been moving towards increasing the use of project bank accounts on public projects, with the Welsh Assembly taking a particular lead mandating these on all centrally procured building projects over £2 million. There was a private member's bill put forward in the last Parliament requiring public authorities to pay certain suppliers using a project bank account, but sadly it didn't make progress to a second reading, so will now need to be resurrected to make such progress. I think it's also important to highlight that whilst in the public sector the government has been putting pressure on these being included, the uptake has been limited on private sector projects. So we're going to kick off the talk today with a little overview of retentions, and it's common to see retentions of between 3 to 5% withheld by the employer or main contractor, and these are usually held and released in two tranches, 50% on practical completion and 50% on the certificate of making good defect. Some specialist subcontractors have been able to push back successfully and refuse retentions, but I tend to see retentions on the vast majority of the projects that I'm involved in. Now, the question is, are retentions an effective and cost-efficient means of providing surety against defects? Or alternatively, are they an outdated and increasing source of cash flow pressure? This is the question that industry is grappling with at the moment. They were originally implemented to deal with the massive building projects associated with the Industrial Revolution, rail, etc. And as I said, they now appear on most projects. An alternative to retentions is the provision of a retention bond, and there is wording in the JCT contract for this. However, retention bonds can be expensive and they're not commonly used. It's estimated that there's a loss of approximately £229 million a year of retention payments due to upstream insolvency. Now, it's not usual for retention monies to be held on trust. The standard JCT provision is that they ought to be held on trust, but this is usually amended at the contract negotiation stage. Last year, there was progress being made through Parliament for the Aldous Bill, which related to the introduction of a retention deposit scheme similar to the tenancy deposit scheme. However, this didn't progress because of the prorogation of Parliament. Finally, Build UK also published a retentions roadmap to zero retentions by 2023-2025. In December 2019, the Construction Leadership Council backed the Build UK roadmap to zero retentions, and this supported the abolition of retentions by no later than 2025. They also included mention of certain standards, i.e. that arrangements for retentions for no should be no more onerous than the main contract and only deducted for permanent works, and also they shouldn't apply to contracts with a value of less than 50,000, increasing to £100,000 in 2021. And I thought this was quite useful to mention because this might be something that some of you on the call might want to mention in some of your negotiations about trying to get rid of retentions. So we've touched briefly on the much published Aldous Bill, and I also wanted to flag that a couple of weeks ago, the results of the 2017 consultation on the use of retentions was finally published by the government. And I've summarised some of the statistics on the slide above. Now, although there seems to be some enthusiasm for tackling the issue of retentions, I would flag that the debate transcript from Parliament on the 27th of February 2020, which is available on the Construction Minister's website, zawari.com, the outcome of the discussion appears to be that it's a bit complicated, so little progress has been made in the search for a solution. This is clearly a shame given the progress the Aldous Bill had made previously. In addition, the Construction Minister has recently insisted that there's no clear majority supporting any solution at the moment, and it's right for the government to begin to distill opinions and come to a view. Now, I am aware that many industry bodies such as BSA and ECA are currently having high-level discussions with government about retentions and late payment to try and find some mutually agreeable solution. So let's look in a bit more detail at the interim payment terms in the JCT Design and Build Subcontract 2016. So the JCT 2016 suite made a number of changes designed to reflect fair payment. It introduced a common valuation date which applies throughout the contractual chain. And this common date is a date which is the same in the main contract, the subcontract, and the sub-subcontract. This improves the speed at which subcontractors and sub-subcontractors can get paid. Under the main contract, the parties choose the first interim valuation date, which is stated in the contract particulars. Subsequent interim valuation dates will be the same date in each month or the nearest business day in that month. If the parties do not choose the first interim valuation date, the default position is 1 month after the date of possession. The interim valuation dates apply for both Alternative A, which is stage payments, and Alternative B, which is periodic payments. And interim applications continue until after practical completion. Practically, if the interim valuation date, for example, falls on a Saturday, the interim valuation date will be the Friday, as this will be the nearest business day in the month. Alternatively, if an interim valuation day fell on a bank holiday Monday, the closest business day would be a Tuesday. Due to the changes in counting days, this will affect the due date and the 5-day period for the issue of the payment notice, the last day for giving a pay less notice, and the final date for payment. Employers and contractors who are making payment under subcontracts should bear in mind the importance of serving payment notices and pay less notices on time to avoid losing the contractual right to do so. If the payment provisions are unamended, payment ought to be made from top to bottom within 31 days. So the tip, just to recap on the tip. So tip 1, agree fair payment terms, and tip 2, get notices right. It's really important to take great care with notices and notifications under the contract. As you will know, there are quite specific periods for payment which require careful attention to ensure entitlements are not lost. Consider the schedule of notices required under the contract and in law. Perhaps consider automating it. There are apps and software available to assist with this. At the very least, ensure you have a schedule in place for your project so you know exactly when notices are due under the contract. So we're going to focus again on the design and build subcontract. Under the main contract, the contractor can make an application before the interim valuation date, and the due date for payment is 7 days after the interim valuation date. If the application is late, the due date is pushed to 7 days after the application. The JCT subcontract sets the due date 12 days after the interim valuation date, so that the main contractor is put in funds with a 5-day margin, and there is an option for the subcontractor to submit an application at least 4 days before the interim valuation date, so the contractor can include that in its application upstream. The JCT subcontract steps the due date 17 days after the interim valuation date, again with a 5-day margin. The final date for payment is 14 days from the due date. A payment notice is required within 5 days of the due date. If it is not given, then the application is a default payment notice and is the sum payable, i.e. the notified sum, unless a pay less notice is given. On this on this slide, we've set out kind of a pictorial representation of the payment process. So the parties can choose the first interim valuation date. And as set out on the slide, the interim payment due date is 7 days after the interim valuation date under the main contract, 12 days in the subcontract, and 17 days in the sub-subcontract. Unless clause 4.62 of the subcontract applies, in which case a subcontractor has to make a payment application no later than 4 days before the interim valuation date, or at any time after, if the contractor has not in the meantime issued its own payment notice within 5 days of the interim payment due date. If, however, clause 4.62 applies and a payment application is not made by no later than 4 days before the interim valuation date, the interim payment due date is 16 days after receipt of that application. So as you can see from this, timings are key. So we're going to have a quick reminder on the content of a pay less notice. So if the contractor intends to pay less than the sum due in a payment notice or an interim or final payment application, or the paying party intends to pay less than the sum stated in the relevant payment notice, a pay less notice can be served by the payer not later than 5 days before the final date for payment. And the paying party must pay the sum set out in that notice on or before the final date for payment. Now, it's important to note that a pay less notice should be served even if the sum that you intend to pay is 0. It's common for the payment period to be reduced from 5 days before the final date for period to a much shorter period, i.e. 1 day. If there's no valid payment or pay less notice, then the paying party has to pay the notified sum, which will be in the application for payment. And it's important to remember the relevant maxim is pay now, argue later. In a recent Court of Appeal decision called ST and Grove, the Court of Appeal has said that if there's no payment or pay less notice, or those notices are not valid, then the payee, so the party expecting payment, can adjudicate to be paid the notified sum. And a true value adjudication, which would be an adjudication as to the actual value of a particular application, can only follow once after payment has been made to the party expecting payment. Just wanted to quickly flag the arrangements now for the final payment under the subcontract. So the due date for the final payment is 2 months after whichever of the following occurs last. This is in clause 4.22. So it's either of the retention release date, any later due date for retention release, or the date of issue of the contractor's calculation of the final subcontract sum. So by way of recap, we've done tips 1, agree fair payment terms. Tip 2, get notices right. And tip 3 is in relation to your entitlement to variations. This is an entitlement to extra time and sometimes money under the contract. Be careful to make clear claims for any variations in the form specified in the contract within any timeframes that are specified. Much here will depend on the particular terms of the contract. Notices of variation must be issued and responded to within correct timeframes and issued in the correct form. And consider also overheads and other costs impacted by variations. So contractors are entitled to be paid for extra work or variations carried out under a construction contract. And the JCT provides for how an instruction may be given and whether a contractor is entitled to be paid for the variation and how it may be valued. And that's what we're going to look at now. So I keep jumping the slides, apologies. Whether or not an instruction is a variation depends on the facts and is defined in clause 5.1 of the JCT subcontract. Variation is an alteration or a modification of design or quality and quantity of works, and it's also the imposition of additional obligations or restrictions concerning access, working space, working hours, and the sequencing of works. Now, one issue that commonly arises in relation to variations for bespoke and standard form contracts is how a contractor should give notice of variations and changes. If the contract contains notice provisions, care must be taken to ensure that they're complied with. If not, depending on the construction of the contract, there's a danger that any claim for additional payment will fail. As set out on the slide, clause 1.7 requires that any instruction should be given in writing, and clause 3.7 does recognise oral instructions. So clause 3.7.3 gives the contractor the power to retrospectively confirm an oral instruction which had not been confirmed by the procedure in clause 3.7.1. However, there's no entitlement to payment for additional work which was not prompted in any way by an instruction. The wording of the clause is where the contractor gives a direction to the subcontractor, otherwise than in writing, it shall be of no immediate effect, but the subcontractor shall confirm its terms in writing, and it shall take effect as from the expiration of the latter 7-day period. So the important thing to remember here is if you've been asked to vary your works, but there's been no written instruction, it's really important that you follow that up with a request for a written instruction as soon as possible. So as set out on the slide, a variation can entitle you to time under the contract if it's a relevant subcontract event, and loss and expense can also be recovered for variations as it's a relevant subcontract matter. Now, notices are required under both of these provisions. Under clause 217.1, which is relating to claims for time, the subcontractor shall notify if and whenever it becomes reasonably apparent that the commencement, progress, or completion of the subcontract works is being or is likely to be delayed, and the subcontractor is to notify the contractor forthwith. Certain information has to be given to the contractor, which includes a description of the material circumstances, a statement of the causes, whether it is and what relevant subcontract event applies, and also the likely period of delay. Under clause 4.15.1, which relates to claims for loss and expense, the subcontractor shall notify as soon as the likely effect of a relevant subcontract matter and regular process becomes or should have become immediately apparent to him. So what must evaluation of work include, and what happens if you're asked to provide a variation quotation? Well, the contractor's valuation of work must include variations that have been included, and the contractor can ask the subcontractor to provide it with a variation quotation. If this happens, the subcontractor can ask within 4 days of that request for further information and more time. The subcontractor can also refuse to quote, in which case the contractor can instruct the work to be valued under an interim application. Now, if you are asked to provide a variation quotation, this must contain specific information as required by Schedule 2 of the subcontract. It must include, for example, the required adjustment to the subcontract sum, notification of additional time for completion of the subcontract works, loss and expense payable, a reasonable cost of preparing the quote, and if requested, resource and methodology required for the variation. A variation quotation must be submitted within 14 days of the contractor's request or on receipt of additional information required, and a quote remains open for acceptance for a minimum of 14 days from receipt. The contractor's acceptance of a quotation must state the adjustment to be made and the extension of time that's been agreed. The contractor can also direct the variation to be carried out under the valuation rules or instruct the variation not to be carried out. The subcontractor has the right to request its presence at any measurement by the subcontractor for the purposes of evaluation, including of a variation. And there can be a deemed variation by clause 5.11 if a variation results in a substantial change in conditions under which other work is executed. So just to recap on the tips. So tip 1 was to agree fair payment terms at the outset, if you can. Tip 2, get notices right. Ensure that you issue pay less notices, payment notices, make sure that your payment application has been submitted in time. Tip 3 was relating to variations, check your entitlements and follow the process in the contract. And tip 4 was we're now going to look at complying with conditions precedent to entitlement. In order to ensure entitlements to payment, there may be requirements in the contract known as conditions precedent, which mean that specific conditions of the contract which must be met before you're entitled to the benefit. The law has very specific requirements for a condition to be precedent, and these are set out in case law. Right, sorry, I've jumped ahead again. It's important to note that not all notice clauses are conditions precedent, and it's vital that time and money claims are made under the terms of the contract and any procedures are followed, as time bars are often used. Time bars are used so that an employer gets notified promptly. The contractor does not stockpile notices, and it should be noted that time bar increases the risk of administering the contract for both parties. Like, if you're trying to consider whether or not it's a condition precedent, the starting point is the Bremer case, which is summarised on the slide. This case said that a condition precedent will be decided on a contract-by-contract basis, and a breach where the clause is not a condition precedent will normally only permit normal breach of contract claims. If it is a condition precedent, the usual rule is it should state a precise time limit and state the consequences of failure to provide the notice. In a more recent case in 2007 of Steria and Sigma, one area of substantial dispute in the case was the proper construction of the extension of time provisions in the subcontract, and whether or not the requirement for giving written notice of delay was a condition precedent to an extension of time. The judge held that the phrase in a clause, provided the subcontractor shall give given within a reasonable period written notice to the contractor of the circumstances giving rise to the delay, was clear and was a condition precedent despite not setting out the consequences. This was a looser interpretation than in Bremer. If there's any ambiguity, a clause ought not to be construed as a condition precedent. So what I recommend that you do when you're looking at any amendments to your contracts is to watch out for wording that might be indicative of a condition precedent, such as provided that. So to go back specifically to the JCT Design and Build subcontract, Clause 217.1 sets out the subcontractor's obligations to notify in relation to delay. It should be noted that the obligation arises not just when progress is being delayed, but also when it becomes reasonably apparent that it is likely to be delayed, and also that it arises in relation to any cause of delay or likely delay. The subcontractor must notify the contractor forthwith of circumstances that will or are likely to delay the progress of the work. But forthwith is not a precise time period for giving notice as required in Bremer, and it is open to interpretation as to how long this would give the contractor to give notice to the employer. Again, note in law the importance of language and its interpretation. The JCT subcontract also does not specifically state that failure to provide notice forthwith will cause the contractor to lose its entitlement to claim an extension of time. However, I would note that there is a long stop date for the award of an extension of time, which is 16 weeks after practical completion, and it's in clause 218.5. In spite of the Steria decision and the similarity in the wording in that case, this clause, i.e. clause 217.1, and the equivalent provisions in the other JCT forms is not considered to be a condition precedent. As there's no precise time period in which the subcontractor needs to notify the contractor of a delay to progress, and so the subcontractor's obligation in clause 217 can be open to interpretation. The clause also doesn't set out the consequences or a failure of the subcontractor in not notifying the contractor forthwith of the delay. As this wording is not generally considered to be a condition precedent, we often see this clause amended, so it is a condition precedent, i.e. the imposition of an express time limit and setting out specific consequences. Looking now at loss and expense claims, a subcontractor should notify the contractor as soon as reasonably apparent. The wording of the clause is that they should notify as soon as the likely effect of a relevant matter on regular progress becomes reasonably apparent, and that's in clause 415. This may be a condition precedent, particularly because clause 414.1 specifically requires compliance with 415. Now, on the subject of what information needs to be submitted with together with an application for an extension of time or loss and expense, the Walter Lilly case can be used here to give you some further information about the level of detail and information. In the Walter Lilly case, the relevant clause of the main contract required the contractors to submit to the architect such details as would reasonably enable him to ascertain the extent of loss and expense, and the court considered what information must be provided pursuant to this clause. They decided that the extent of information already available to the architect, for example through site meetings, must be taken into account in considering the contractor's obligations for provision of information. The contractual obligation was to submit details which are reasonably necessary for the ascertainment of loss and expense. This requirement may be met by an offer to the architect or engineer to inspect records at the contractor's office, as actually occurred in this case. Whilst it will be possible for a clause to require that the contractor should provide details and all necessary supporting documentation, that is not what the clause said in this case. Finally, they said that the architect must be satisfied that the loss and expense claimed is likely to be or has been incurred, but he does not have to be certain. He only needs to review all the detail that is reasonably required by the wording of the clause. So just to recap, our notices are conditions precedent under the JCT. Just need to check when you should notify. And as I said, you need to notify in relation to 415.1 as soon as the likely effect of a relevant matter on regular progress becomes reasonably apparent. And that notification should be supported by the subcontractor's initial assessment and information. The contractor is to notify its ascertainment within 42 days of the initial application, and then the subcontractor must update this at monthly intervals. So just to recap on the tips. So tip 1, agree fair payment terms. Tip 2, get your notices right. Tip 3, variations, check your entitlements. Tip 4, comply with any conditions precedent to entitlement. And tip 5, resolve or avoid disputes proactively. And that's what we're going to look at for the final section of the talk today. So disputes are costly, so putting in place strategies to tackle them is key. And if a dispute arises, careful management of the process is really important. So how do you avoid a dispute? Well, it's a truism that you only recognise the importance of trying to avoid a dispute once you've been through a dispute in the first place. And these are our top tips for best practice based on our experience of handling various disputes. So the first one is contract and project management. So we think it's really important to monitor internal reporting and to keep on top of internal reporting from the site up to the commercial team, but always to ask the question, is it accurate or is it what they want to hear? If it's not accurate, issues may develop unchecked, and you need to consider carefully how you can ensure the accuracy of information that you're receiving from the site team. For example, incentivising issue reporting and focusing on site supervision. When issues are raised, these should be investigated and you should take action as needed. We suggest that you consider preparing an issue file and a live updated chronology tracking what's happening on a particular dispute with a file of key documents. This means that if the issue progresses, you already have the key documents to hand and don't have to go through thousands and thousands of emails or folders or project folders. The second is to monitor the issues that arise. Sometimes it's helpful to get an objective view from someone that's detached from the day-to-day events and the personalities involved. Ensure that follow-up steps are taken. So if there's outstanding correspondence or calls, make sure that they're logged and followed up, and check that any solutions that are agreed are implemented and working, for example, revised procedures, etc. Record keeping is absolutely crucial and probably one of the most important things that you can do, and that's really helpful in the event of any dispute. Now, record keeping is not just about keeping emails and not just email folders. And during the course of a general construction project, we appreciate that thousands and thousands of documents can be created, but there's no use in having all of these documents unless you can use the data in them, and you can't do this unless they can be organised and searchable. So what matters, both in the early stages of an issue coming to light and at the final hearing, is not what actually happened, but what you can prove happened, which is why records are so important. So some examples of good practice are to record conversations in writing, even if you send a follow-up text message or email. For example, a dispute might have been avoided about a call-off contract if there'd been a written record of what was ordered on the telephone. We suggest that you keep original notes of all meetings that you attend with dates on them, perhaps in a notebook. Because even if the formal minutes are produced, these can be sanitized and may misrepresent the precise order that details were mentioned in, or who rather than which company said something. Photographs are also very useful, but they're only really useful if they have a date timestamp on them and a reference point to locate them on a site. Consider, for example, using trees, buildings, telegraph poles. You can also use tech available. For example, many of the smartphones that we all carry about can take panoramic photographs. Alternatively, organise photos in a sequence, either left to right or zoomed in to situate the detail on site, for example, a pipe valve. The fourth bullet point is to monitor the behaviour of other parties on site. This can be relevant for issues or problems generally. Throughout the life of the project, be alive to changes, whether it's changes of behaviour, changes in personnel. This can indicate underlying problems, including insolvency. Some consultants, for example, are exploring the use of artificial intelligence and sentiment analysis to monitor project correspondence, to detect when tone changes or when usual recipients change, which may indicate an issue to be investigated. Our final top tip for avoiding disputes is to comply with the contract machinery, particularly notices and conditions precedent, and some of which we've gone through in our talk earlier today. We think it's really important, if you can, to create an internal system to track deadlines for notices, and also to track any key milestones, etc., that you need to meet under the project. Make sure that you're tracking the right deadlines. Is it the relevant date when something is sent or received? Are there rules on when it's deemed received or how it has to be sent? There's usually, for example, a notices provision in the contract that explains quite clearly where notices need to be sent to and in what format, whether they can be sent by email or by post, etc., etc. Getting the right notice in the right form by the correct deadline can be the difference between ending up in a dispute or not. So after doing all that you can to avoid a dispute, you still end up in a dispute. How do you best manage one? Well, when preparing a claim, we think that it's always really important to try and get a set of fresh eyes to have a look at the claim, whether that's professional advice such as a lawyer or whether that's somebody else within the business. Get someone objective, not involved in the personalities and the relationships, etc., to review it and produce the claim if possible. They'll also be less likely to use emotive language. Painting a picture of a disorganised company will annoy the other side, and it won't help you win in the eyes of a third party if you cannot demonstrate cause and effect. It's really important to make precise statements that are supported by reference to specific documents. For example, poor claim submissions make unsupported sweeping statements like factors outside our control or the works became increasingly complex. Whereas it'd be much better to say something along the lines of the site management was often disorganised, for example, and this means that, setting out the effects. It's really important to establish cause and effect between the problems you complain of, for example, a lack of instruction, and the effect, for example, delays and increased costs. The second point is to be prepared as soon as possible. Consider the issue file I mentioned when talking about record keeping. If you haven't got them already, get your documents in order. Consider also securing samples. Speak to the relevant people as soon as possible because memories fade fast. Get them to write down everything they remember, and it may help you to see where the problem arose and will help later with any witness statements. On the fourth bullet point, we mentioned early case assessment. This is effectively where you do a review of the key documents and facts to provide an early assessment of the merits of pursuing a claim. This will help you decide whether to invest the time and resources in pursuing a claim, and it's more accurate and useful if you're able to provide the relevant key info. Again, records. Internal organisation. If you've got an ongoing project, considering having a separate project and claim team to preserve ongoing relationships. Always consider whether you need to notify insurers, particularly if it involves defects, and consider involving third parties such as lawyers or experts at an early stage. If you are going to appoint experts, we suggest that you do this via a lawyer to ensure that you maintain privilege in the advice that they give you. And it's also important to find an independent expert. Make sure you start the claim on the right basis. If you don't, then you may not be able to change it later, and it will give a bad impression if you will do so. In litigation, for example, you may not be allowed to change your claim if you leave it too late, so there isn't time to deal with it in the process. Permission may also depend on whether you had the information to bring the right case from the start. Even if you're allowed to amend your case, you have to pay the other side's costs of responding to it. Now, in conclusion, some of these points may seem obvious or perhaps a bit overkill, but these are all things we've either seen being done which have helped avoid a dispute, or we've seen the problems arising from these things not having been done. I think probably the biggest takeaway in terms of preparing and managing for a dispute is the importance of record keeping throughout the project and keeping those records organised. Now, just to recap on the 5 tips that we've been through today, the first tip, agree fair payment terms. As I said at the outset, it's the single most important thing that you can do to make sure that you enter into a contract with payment terms that are not weighted against you to start with. If you don't feel that you can't raise objections to these particular provisions at the outset. And remember, for example, what we talked about in relation to retentions. So, for instance, if you want to resist a retentions provision, you could cite the latest announcement by the Construction Leadership Council about when retention should be utilised. The second tip is to do with getting notices right. And we talked about the importance of getting your application in if you're required to make an application, because in the event that a pay less or a payment notice is not issued, that can include the notified sum. We talked about the importance of the payment notices and the pay less notices. There's all sorts of particular requirements about the contents of those notices and the timing, which is very, very critical. The third tip was to make sure that if you're entitled to, if variations are instructed under your contract, make sure that you don't lose any entitlements to those. Instructions should be in writing. If they're not in writing under the JCT subcontract, you have the opportunity to request follow-up in writing and confirm it in writing. There's also a particular process for applying for valuing those variations, and those should be followed. Then the fourth tip is to comply with any conditions precedent to entitlements, and we talked particularly about entitlement to any extensions of time and loss and expense, and the wording of those provisions in the JCT contract and whether or not they were a conditions precedent. It's really important that you comply with the requirements of the contract, including form and content and also timing. The fifth tip, which we've just run through, was tips on how to resolve and avoid disputes, and emphasising in particular good record keeping. Now, just to kind of wrap things up, I just wanted to briefly explore the possible reasons for late payment. Now, I think it's probably fair to say that there's various reasons why payment might be late. Not all of these will be because of bad intentions. Sometimes it's bad processes, for example, failure to issue notices, etc. on time. Sometimes it's bad practices, which might be a cultural issue, cultural issues within the sector. Or alternatively, there may be upward payment issues, for example, insolvency, solvency risk, or there may be a lack of security up the line. I see quite a lot of projects at the moment where the employer is a kind of a shell company, and funding is coming from overseas, which can cause a lot of delays. I'm increasingly seeing contractors getting as many forms of security as they can, including escrow accounts, for example, to make sure that they have access to the money. I think it's really important to emphasise that, it's your money. You need to try and stay in control of getting it back. You need to be proactive in terms of taking steps to get it back. And also, I can't emphasise enough the importance of perseverance, of pester power. And I think the final comment really is the best opportunity to deal with fair payment and to ensure fair payment is to set fair payment terms at the outset, if you can, and to follow the provisions of the contract. Now, that's a bit of a whistle-stop tour, but Jordan, that kind of concludes the me talking bit. So I'm happy to take any questions that you may have.
Okay, thank you very much for that, Ruth. So at the moment, as it stands, we haven't had any questions come through. So what I'll just mention a few things, and then if we get any come through in the next sort of 5 minutes, then we'll go through them. So with that, I just want to thank Ruth for joining us this morning and providing that presentation for us all. It will be uploaded to our YouTube channel, so if you have any colleagues or know of anyone that you think it would be of interest to, please do let them know and send them over the link. Our next webinar is on the 22nd of April, so this is going to be with our Chief Operating Officer at CABE, Jackie McCauley. For anyone who isn't aware, we have been awarded our licence with the Engineering Council, so Jackie is providing a webinar on CEng registration. So please do come online and listen to that. I know she has provided a webinar in the past, but I think this one will definitely generate some interest. If you've got any feedback on the webinars that we provide, or if there's any topics that you'd like to see covered, please do send them over to me. Anything that would make a good sort of 40-minute presentation with time for questions at the end would be great. Or if you think that you yourself can do one, please do let us know. We're always looking to get on board with our members. Just to mention again, our Built Environment Awards are now open for entries. So please do send through any queries or any submissions to myself. Just want to take a couple of moments to mention some courses that we've got coming up at HQ. So on the 20th of March, we've got Fire Safety Codes for Building Design, BS 9999. Then we have Dealing with Dangerous Structures and Demolitions on the 28th of April. And finally, on the 30th, we have Future Homes Part L. So just having another quick look, I don't think we've had any questions come through. If you do have any, please send them through to myself, or you can send them through to the info at email address, and I will send these over to Ruth outside of this morning's session. With that, I'll wrap up. Thank you again for delivering that presentation for us, Ruth, and hopefully we'll see you all online next month.